How are you all?
Good afternoon, Judge.
Welcome.
I'm told to sit at the green tablecloth.
You are at the green
So
table.
I'm here at the green tablecloth.
You can't miss it. Well, good afternoon. Welcome to Oviedo. Welcome to Judah.
Right, thank you.
As you know, I'm Amanda Carl. I'm the Vice Chair at PCAJNC. You've been in front of us before, so you kind of know the process.
Yes, ma'am.
We will all go around, introduce ourselves, tell you where we're from, and then you'll have 2 minutes to make an opening statement.
Okay.
We'll have questioning, and then you'll have a minute at the end to make any closing statement. We do have one difference today. We have Lucia exposed here with the video camera.
Okay.
Sit tall and smile pretty, and we will get started.
Sure.
Craig, let's go with you.
Greg Dyer,
Yes.
Public Defender's Office, Detroit Beach.
Nice to meet you.
Good afternoon, Your Honor. Petra Brownlee, the Brownlee Law Firm.
Good afternoon, Your Honor. Brett Brennan, Schutz and Bowen.
Good afternoon, Andy Bardos with the Gray Robinson Law Firm.
Good afternoon, Your Honor. Known each other for years, but Vince Citro with the offices of Horowitz and Citro.
Nice to see you again.
Good
Likewise.
afternoon, I'm David DeArmas, Kramer Price and DeArmas in Orlando.
Okay, thank you. All right. The question that normally gets asked is, why do we want to do this, or why would you want to be in this position? And my answer for you is this. I sat back and I've reflected about what it is that I like about the practice of law. I started at UCF as an engineering student, did 3.5 years, and decided I didn't want to be an engineer. I got fortunate enough to get a job in a law firm, and what I enjoyed about that was looking at and investigating issues and then writing about them and providing a recommendation to somebody as to which way we should proceed on something. As I've gone throughout my career, even as a prosecutor prepping for trials, the things that I enjoyed most about the practice of law was looking at, all right, I have a piece of evidence, I want to get it in. How do I go about doing that? What are the arguments the other side's going to make? What cases do I have or law do I have that supports me? What doesn't? And sometimes you make the decision, I'm not going to be able to get that piece of evidence in because the law doesn't support me. On the other hand, you might say, yeah, I can. And so those are the things that I enjoyed most about being a trial lawyer. And then during my 7 years on the bench, my most enjoyable portions of time are those times when I'm presented with an issue, I need to go back, do some research, and do some writing on it. What solidified for me the desire to apply for the 5th DCA was when Alan Lawson, who was a good friend of mine and a mentor of mine, gave me the opportunity in 2015 to sit for him on the 5th DCA. I sat up there, I got to see what they do on a day-in basis for about a week, and that solidified for me that's where my passion lies and that's what I want to do. So when the openings came up in 2017, that was the first time you all saw me, and then there was one earlier this year, and now again. So that's the reason why I decided to apply.
Judge Tynan, I had the privilege to vet your references and go through your background. And I will tell you, without exception, everybody sung very high praises of you, from Justice Lawson and several members of the judiciary who recalled your time before them as a litigator and how you were always well prepared and anticipated issues and were ready with case law, something that some of them believe is a lost art among the litigators. Your neighbor, of course, told some wonderful stories. Both your neighbors told wonderful stories about you as a dad and as a person, and as someone who was involved very much in the community. My question, and I see that you in your application address this a little bit, that one of the strengths that you perceive that you bring is your experience in criminal law. And yet 80% of the oral arguments that are granted in front of the 5th DCA relate to civil issues. And so while the background in criminal law is a strength, it's also a weakness in that it is not a significant portion of your career where you're looking at civil law issues. So if you were selected by this committee to make the list of 6 and ultimately selected by the governor to sit on the 5th, what is it that you intend to do in order to bridge that gap in experience as it relates to really the broad issues of civil area that go before the 5th DCA?
Well, I understand that on paper a lot of it looks like it's criminal because I was a prosecutor. But as you know, a lot of the time that I was in the prosecutor's office, a third of that time I spent as legal counsel over at the Metropolitan Bureau of Investigation. And primarily what we were doing is advising law enforcement officers on what they could and could not do to avoid civil liability. As a member of that task force, they did not have any immunity other than what was normally granted to them through their agencies. Okay, so a lot of times we would have to advise them you can or cannot do these types of things. A lot of what we did as general counsel to MBI was civil forfeiture proceedings, settlements with claimants and stuff like that. So I do have some civil experience there, even though it looks like on paper it's a prosecutor. There was also 3 years of private practice where I had the opportunity to do both plaintiffs and insurance defense work. So I have about 8 years of experience. I do candidly admit my experience is mostly criminal. To specifically answer your question, my ability to go through and get through some of the appeals, because about 70% of the appeals coming into the 50CA are on criminal trials or criminal post-conviction relief denials or of claims. And so the criminal experience is going to help me to be able to get through that workload quicker so that I can dedicate more time to those areas that I may not be as experienced in. I candidly admit there are places where I'm going to have to do a lot more work than maybe some of the colleagues up there to get up to speed in things such as divorce and those types of things. But I don't think that you should apply for the position if you're not willing to put that time in. My criminal experience is going to be able to, like I said, get me through some of that docket faster so that I can dedicate the time that I need to get up to speed on areas where I may not be as strong.
Just a couple of questions for
Sure.
you generally. For this body,
Mhm.
just asking your opinion, do you believe that as a rule, we should not send the names of individuals up who do not have any judicial experience in their background?
As a per se rule, no.
Why?
I think that the qualifications, I mean, there is a strength to being a trial judge, okay, and having had some trial experience, but there is also other strengths as being a lawyer that you don't gather when you're on the trial bench, okay? I think that it's important up at the 50CA that you have a collective body that has a all broad base of experience, because one of the things that you all have to do when you're up there is sit back in those deliberation rooms after oral arguments and discuss amongst your colleagues things that I may be picking up or be aware of because of my trial judge experience or my trial experience as a lawyer will be helpful to those who may not have that. By the same token, somebody who has not been on the bench may have a different perspective and be able to provide input or insight that I might not recognize. So I don't say that there's any per se rule. That, you know, there are rules about who is qualified, who's not qualified in terms of number of years, and then you look at that person's application as a whole. Whether they are a trial judge or not simply is not the benchmark.
Thank you. What's the longest you've taken as a judge to rule on either a motion or after a trial?
The longest, there's only one time that I've been over 60 days.
Okay. And what was that?
That was a case on a DUI manslaughter with Stu Hyman where there were about 16 separate issues raised in the motion to suppress. So it took some time to weed through the 1,000 pages of transcripts over the 6 days of hearing time and some other things. And so that took a little bit longer. We do keep track in our circuit of whether or not a decision's pending more than 60 days. And with the exception of that case, I've never had to tell the chief judge, I've got something pending more than 60 days.
And what do you think is the largest challenge, largest current challenge facing the judicial system in order to ensure and maintain its integrity and independence?
The perception that we are fair, neutral, detached, and calling balls and strikes. I mean, keeping our personal opinions out of it, that's the one thing that we, as members of the judiciary, can't lose. Once we lose that, then we lose all credibility in what we do and what we say.
Thank you.
Judge Tynan, I saw in your application that you've been a guest lecturer at FAMU on judicial philosophies.
Mhm.
Could you tell us about that lecture or lectures and what they consisted of?
Sure. I was asked by one of the professors to come over. They were on it was a subject or a class about different judicial philosophies. My judicial assistant at the time was a student in that class, and he's now graduated and is working at a defense insurance firm. And he asked me if I would come over because he knows the way I think about certain things to give them that perspective, since they had other lecturers come in on that. And I came in and basically gave them my personal philosophy about handling cases, which is to look at the text, look at what it says, give it a plain, ordinary, common sense interpretation. And if that's what it means, and that's what it says, and it's not ambiguous, then that's the way you rule without looking at anything else. That if there is some ambiguity, then there are certain canons of construction and things that you can look at to try and come to a resolution. But absent that, you look at the plain ordinary language. And I know that they had some discussion with the professor and I going back and forth about, well, why can't you, read something into it that's not into it? And although I respectfully disagreed with him, we had a nice discussion about what his philosophy clearly was versus mine. And so I just kind of was there to give the opposite side, I think, of what they were getting from the profession.
Can I ask you with regard to your judicial philosophy then,
Mhm.
where does common law or stare decisis play? What role does it play in that?
As it relates to stare decisis, I think I'm more concerned with getting it right than blindly following something that may be wrong. If you're looking at the Supreme Court justices, you look at Justice Thomas, he's more concerned, I think, with trying to get things right. So if there is stare decisis, an opinion or a ruling out there in the past that's clearly right, fine, you follow it. If it's clearly wrong, then I think it's more important that we get it right and go back and revisit it. Now, under those circumstances, you also have to look at how long it's been there, what kind of damage it's going to do if you undermine it. Something that's been the state of the law for 100 years, that's been relied upon by corporations, businesses, and all those types of things, you might be less inclined to upset the apple cart under those circumstances. But generally speaking, I think it's more important that we get it right. If it's a clearly right decision, then you stick with it. If it's not right, then I think it probably should be revisited.
What about that in the criminal context? I mean, what if you open the gates, what if you reverse that decision and if you knew it would open the floodgates to like a Hearst problem where all of a sudden, you have all of these people applying for successive 3850s or something because, the United States Supreme Court or the Florida Supreme Court then also, deemed their sentences to be unconstitutional. So something's wrong, but you also know will have a huge impact. It's going to increase your burden as a judge.
Understand, and that's one of the considerations you'll look at, is how long has that precedent been out there? How long has it been relied upon? What impact it may have? But ultimately, if it's the right decision, then, part of what we have to do is be honest with ourselves as members of the judiciary and say, you know what, we made a bad call, we need to fix it. It's going to have some consequences, it's going to result in more work, but it's more important to be right than it is to follow along with something that's not right.
Thanks for being here. Is there a case that you have read recently that you thought was particularly well reasoned, or is there one that you felt was poorly reasoned?
I'm
Poorly
really
decided?
excited about an opinion that came out about an hour ago. It's one that affects the PIP insurance claims throughout the state of Florida. It originally came out of the county court in our circuit. I was the presiding judge over a 3-judge panel that issued the ruling. It was affirmed by the 5th DCA. There was a 4th DCA opinion that just recently, that recently came out in conflict with it. It went up to the Supreme Court. Those arguments, or not arguments, but the pleadings and briefings and stuff were done, and I got an email fortuitously as I was sitting in the parking lot at 2 o'clock from the Supreme Court, where Justice Kennedy affirmed the 5th DCA's ruling and our ruling on that PIP claim, which had to do with just the interpretation of the plain language of the PIP statute as it relates to how you calculate the deductibles. And so I'm kind of happy about that one. Other ones that I've read recently, in the last month and a half, we've had some really good opinions out of the Supreme Court. There was one about prison releasee reoffenders. I think it was Luar is the name of the case, which was an interpretation of what the phrase release from a DOC facility means. The argument there was that somebody was released from a county facility even though they were given a DOC sentence. And Justice Lawson said, well, that's not the plain language of the statute. It says released from a DOC facility. A county facility is municipal in nature, or a county facility. It's not there. And he did a nice job in that opinion, if you look at it, of not only saying this is what the plain language of the statute means, but then he went through several different canons of construction to justify that position. And so I think that was a well-written opinion. There was one recently that touched on stare decisis that was written by LaBargia, where they went back and revisited what the definition of a weapon was in the context of a previous opinion called Hope. And they receded from that and said, maybe we got that wrong. It was a little too narrow. Using a car to hit somebody probably could be a weapon. And so they went and looked at that. And then there's some other interesting evidentiary ones that came out. Knock is one that comes to mind. That's going to kind of change the way I think prosecutors are going to present statements made by suspects. Not necessarily putting the transcript or the recording in, but just having the officer orally present it, because then they can't get the rule of completeness and some things like that. So those are some interesting opinions that have come out that I just kind of keep an eye on.
Thank you.
Do you read the Florida Law Weekly regularly? Is that how you're so up to date on it?
Yes, ma'am. Every Saturday when my girls are at gymnastics, I have my computer with me, and I go to the Supreme Court's website and read the opinions. I go to all the DCA's websites and read the opinions off the computer.
What do you think about PCAs?
I know there's a complaint and a perception that there are a lot of them. You know, I think the duty as a member of the judiciary is, if there's an issue to write about, then we should write about it. If there is really nothing to write about or nothing new to write about, then a PCA is appropriate. I understand that there's a desire or a need to kind of explain sometimes what our reasonings are or what our rationales are. And so I think, you know, pinpoint sites to certain cases that might have that analysis in there with a PCA would be a way to kind of clue the parties into, this is where we're at and this is what we're thinking about and this is the reason for what we did. But I think, you know, as long as there's an issue to write about, then there should be a written opinion, not necessarily a PCA. If it's a clear cut of law and there's no new issue that needs to be discussed, then there's really no reason to write the opinion.
Other questions? We have time for another question.
So with regard to the prosecutors introducing the defendants or suspects' statements, is that a change from how Florida had in the past? And if so, do you think that's a change that protects or?
No, I think it's just a strategic change. With the Knock opinion, Knock now says that you don't necessarily, well, the rule of completeness only applies to the introduction of the written statement or the recording of the audio statement or a video statement. If you put the detective on the stand, the rule of completeness doesn't apply, so the defense doesn't get to file in all of the information that's in those statements.
So have you had that challenged yet vis-a-vis the case law in the 11th Circuit is entirely opposite of that, and that is to protect and require by due process even the oral statement, the rule of completeness applies. And so any introduction by the government of a suspect or defendant statements, whether it's by recorded means or by testimonial means, dictates under the rule of completeness the remainder of it coming in.
Right, but that's an interpretation of federal evidentiary law versus the Florida's interpretation of its own evidence code. I think it's
Well,
just going to
the
be
due-
interesting to
yes,
see how they
the
change.
due process analysis
Right.
that the 11th Circuit relied on. So I'll be curious to see how that plays out.
I will too. I mean, that wasn't the argument in Knock, and
Yeah.
that's certainly going to be something that's going to come up, I'm sure.
All right, if you would like to make a few closing remarks,
Sure.
feel free.
You know, I've already told you the reason why I want to apply for the position, and I'll tell you why I think that I am qualified. You know, I've put it in the application, but I think it bears repeating. I've got, you know, more than 2 decades of criminal trial experience and some civil trial experience. So that trial experience is going to give me a unique perspective about issues that come up from appeals and trial cases. My experience is both civil and criminal. Although of late most of that's criminal, but as I said, I think that that's a strength. That's something that I can use to help me resolve what is the primary majority of the caseload, which is about 70%, and that gives me more time to dedicate to those areas that I may not be as strong on. And the last thing I will leave you is this. You know, for most of my career, I've been given a lot of authority and a lot of power. Prosecutors are probably the most powerful people in the courtroom. If you've ever been in a criminal courtroom, you'll know this. They have the ability to decide what you're charged with, how bad it gets, what the offers are, and many of those things. And so as a prosecutor, one of the things that you struggle with is learning restraint. You have to learn when it's appropriate to exercise the immense amount of power that you give. And I did that for 15 years, was fortunate enough to have some really great mentors in that area that taught me, look, just because you can do something doesn't mean you should do something, okay? By the same token, for the last 7 years, I've had the opportunity to serve on the judiciary. And again, judges are given a lot of power, they're given a lot of authority, but it's important that you remember that there are restraints that go on that power. You need to stay in your lane, you need to decide those issues that are presented to you, don't go out on other tangents, keep your personal opinions out of it, and all those things. So I think if you looked at my body of work, if you've talked to the people that are listed in that application, I think they would tell you that probably when I started as a young prosecutor, I didn't know restraint. All right, it was something that I had to learn. I think that if you talk to most of them in my later years as a prosecutor, they would say tough, where he needs to be, but fair. In other words, I learned restraint. And I think that if you talk to the people that have been before me, you'll see again that I exercised restraint. And I think that's an important quality that you all need to take into consideration for this position. All right.
Thank you so much.
Thank you very
All
much.
right, thank you.
Judge.
Happy holidays to you all.